Today, the community planning conversation is with Joe Hooker. Joe is the Assistant City Attorney for the City of Champaign, and I've asked Joe to join me to talk about planning law. Now, many people think planning law is a very dry topic, and why in the world would we want to talk about that? But planning law is the foundation for everything that really happens in our communities, where things are placed, where buildings go, the size of buildings, the setbacks. So it is really very important to understand it and to appreciate how these policies develop and how they impinge upon what we do within our communities. Joe, thank you so much for coming. And Joe has a wonderful PowerPoint that he has brought along to talk to us and teach us a bit about planning law.
Very good. Well, it's a pleasure to be here, and actually my focus is going to be on recent developments in the law of eminent domain.
Very important.
Very important, and actually has generated more controversy than any planning law issue I can think of in recent decades, really. A couple of particularly a Supreme Court case, U.S. Supreme Court case, the Kelo case that we'll talk about, and also an Illinois Supreme Court case that was decided in 2002 that is more directly affects us here in Illinois because it interprets the Illinois Constitution. But anyway, we can start that presentation. If
That would be excellent, and I'm certain that many of our viewers, when you start talking about the Kelo case, will resonate with it because it got a lot of national press over a long period of time.
It certainly did. It just, I think it's accurate to state that most of us practitioners, we're a little bit off the screen here.
That's okay.
We're taken aback, for want of a better way to describe it, by the public reaction. Everyone knew it was going to be an important decision dealing specifically with the issue of whether takings or the exercise of eminent domain was appropriate for economic development.
Why don't you explain what takings is?
Well, takings, eminent domain is basically the power that a state government or local governments, by virtue of delegation from the state, have to acquire involuntarily property from private property owners for public uses or purposes. And as we'll see from this presentation, it's not quite as simple as it might sound as far as how far or what the scope of that power is, and that was the focus of the recent Kelo decision. And if we could go back to the PowerPoint, there's two recurring themes in planning law that certainly come to the fore in this issue of eminent domain. One is there's this constant determination of how to strike a proper balance between the welfare of the general public and the property rights of individual citizens, and we'll see that that's certainly one of the background issues here. The second would be when does the judicial branch defer to the judgment of the legislative branch when those acts of the legislature conflict with the rights or interests of property owners? And we've got there's some philosophical underpinnings of this sensitivity that we have in our country here about private property rights. And we've got a couple of interesting quotes here. One from John Locke, a philosopher from the 17th century who many of the founding fathers revered. And here's a quote from him. It's kind of an interesting one. The great and chief end, therefore, of men's uniting into commonwealths and putting themselves under government is the preservation of their property. So certainly some people thought that one of the main reasons we were putting together our government was to protect property interests. And here's a quote from James Madison, of course, one of the founding fathers and one of our presidents. That alone is just government which impartially secures to every man whatever is his own. So you get a sense of how, at least in the view of many important people in our history, have viewed the preservation of private property as one of the core functions of government. Well, what is eminent domain? Again, it's the power or the right of a sovereign state or those to whom its power has been delegated, and in most instances we're talking about cities, local governments, to take private property for public use without the owner's consent. That's the key there. That's when the exercise comes into play, when the government hasn't been able to voluntarily acquire the property from the property owner.
So that means the city could just come knock on my door and...
Well, there has to be some valid justification, and they have to go through a certain process. But the government does, in a number of instances, have that ultimate authority to do that. And let's look at the origins of the power of eminent domain. It's interesting to note that it predates the adoption of the U.S. or all state constitutions. It's a power that's been inherent in government since ancient times. For sovereign states, and it exists independently in that sense of any constitutions or statutes, but it can be and is restricted or limited by those constitutions and statutes, primarily by requiring just compensation. That's the primary restriction on it. But we'll see that there's also the issue of what is a public use and a valid public use for the purpose of exercising it. And I think it's important to contrast it with the government's police power more generally. That's the power to regulate private property for the public welfare. Examples would be zoning ordinances, building codes, subdivision regulations, and the like. Health codes of various sorts, that would be another police power regulation. This is a more narrow right and certainly a more substantial impact on the property owner, where their rights and interests in the property are completely taken. Let's look at the constitutional restrictions on this power. In the U.S. Constitution, that originates in the Fifth Amendment, which provides at the very end, there's a number of rights that are articulated in that amendment, but at the very end says, "Nor shall private property be taken for public use without just compensation." Our Illinois Constitution has a similar provision that says private property shall not be taken or damaged for public use. Again, that public use concept is there, without just compensation as provided by law. It goes on further to say that a jury makes that determination about just compensation. So what do we mean by the term public use? That's been the key question in these two recent cases that have created such controversy. There's a broader view of some commentators that a use is public for the purpose of eminent domain if it is for a public purpose or benefit. So it's more general than the literal meaning of use that we are familiar with. And again, that narrower view is that it should be construed to be literally something that the public is using, controls, and has access to. That's a narrow view, frankly, put forward by a real small minority of commentators, but that is one view that's held on this particular question.
So if they knocked on my door and wanted my property for a park, then that would be legitimate because that's a public use?
Yes, that would be a good example of a traditional use of eminent domain that really has never been controversial and really challenged seriously. So and now the exercise for the purpose of accumulating parcels for economic development, that has been the controversial use of it, and that was the issue in the Kelo case and in the SWIDA case for that matter.
Okay.
So continuing on, we've got three basic categories of the exercise of eminent domain. We have that we've alluded to, the traditional exercise, which involves acquiring private property for public infrastructure or public facilities. Public schools would be an example, parks or municipal buildings, streets, certainly. And then there's an acquisition for transfer to private parties for the operation of a public conveyance or utilities. Railroads would be a good example. They're typically privately owned, but the power of eminent domain was exercised in many cases in order to facilitate acquiring land to lay down the railroad tracks. And utilities, of course, is a more familiar example more recently. Many utilities are privately owned, and yet they typically will have the power of eminent domain but delegated by the state in order to acquire property to run their power lines and the like. Then we have that last category, and this is the more controversial category, acquisition for transfer to a private entity for some other purpose like redevelopment or blight abatement. Those are the types of purposes, if you will, that have generated most of the litigation on the issue of whether it's a valid public use or not. We've got to, now let's talk about that specific dramatic case in the U.S. Supreme Court. Suzette Kelo, she was one of the petitioners, versus the city of New London, Connecticut, decided last year, 2005. Now let's look at what the competing interests were in this litigation to get a little better context for this. On the one side, you had the city of New London's desire to implement an economic development plan to revitalize the economy of that city. And to understand what the objective was, you need to know a little of the background here. Previously to the controversial takings in question, it was identified by the state as a distressed municipality in 1990 after decades of economic decline. It had lost an additional 1,500 jobs as a result of a closing of a naval station in the Trumbull area of the city in 1996. This is after it was already declared to be a distressed community. And it had an unemployment rate nearly double that of the state. It had a continuing loss of population to just under 24,000, its lowest level since 1920. That gives you a really good idea of how this city had declined in economic welfare. So you can see that if any city needed to have some kind of involvement of government to kickstart its economy, this would be a good candidate, certainly. On the other side, you had 9 property owners who were the petitioners, essentially, and their desire to maintain ownership and control of their homes and rental properties. And Suzette Kelo, who is the named plaintiff in the case name, she was an owner-occupant of her home since 1997. She had made extensive improvements to her house, and it apparently had a very nice view of the water, so she really valued this property and just wasn't willing to sell for this purpose. Another compelling fact situation, you have a Wilhelmina Dairy, I'm probably mispronouncing that, had lived in the house had the house in her family for over 100 years, moved there with her husband when they were married in 1946. So you can just imagine the kind of emotional attachment she had to the house. And then she had her son living next door in the house that he received as a wedding gift. So, of course, these are facts that were cited by the dissent and the opinion just to indicate, in their view, what was at stake and why this case was wrongly decided. They certainly focused in on some of the more compelling facts of the case. It's important to get a full picture of this, to look at the history of New London's development plan that was involved with this exercise of eminent domain. Earlier, the state of Connecticut had created the New London Development Corporation, a private not-for-profit, in 1978 to assist the city to try to reverse the fortunes of its economy. The state authorities authorized $5.35 million in bond issues in 1998 to support what we'll call the NLDC's planning activities. And it's important to recognize that each stage here that we're describing, there's a fair amount of public input. The legislature is, deliberating on what the facts are and what approach to take. So this is not, we don't suddenly get to the point of exercising eminent domain.
So they're following due process.
I don't know if due process is the best term, but they're certainly being very deliberative and not doing this lightly, I think would be a good way to put it. Which some of the critics of the decision would suggest isn't the case. Mm-hmm. In February of 1998, the Pfizer company had decided to put a large research facility in the area, and the city wanted to take advantage of this and see if it could also support other economic development. The city authorized the NLDC to prepare a development plan to promote the redevelopment of Fort Trumbull. Now, this would have been authorized after probably numerous public meetings where the public could participate. And these are elected officials who are making these decisions. It's not just some arbitrary bureaucrat with government, and that's something that's sometimes lost sight of, I think, in these cases. There's numerous public meetings and evaluations by various state agencies before the final plan was drafted and approved by the city council. And these are significant facts that the majority in the opinion focused on, that there was a lot of careful planning that went on here. The plan itself involved approximately 90 acres, in the Fort Trumbull area. Approximately 115 privately owned parcels were in the target area, and 32 acres of this formal naval facility that we talked about earlier. The plan was divided into 7 parcels and was quite ambitious, talking about a waterfront conference hotel, restaurants and retail to provide commercial development, 80 new residents in an urban neighborhood, 90,000 square feet of research and development office space, renovated marina and related parking and services. And the NLDC was authorized also to purchase or acquire properties by exercising eminent domain. But you can get a sense of what a dramatic effect this would have on a community that was as distressed as New London, as far as looking at the public welfare side of the equation, if you will. Well, in the opinion written by Justice John Stevens, writing for a 5-4 majority, basically was that this was a proper example of public use, a valid public use for eminent domain purposes, even though most of the condemned property was going to be transferred to private owners and not be accessible generally to the public. And the key considerations for the majority were several. One, that the takings was part of a comprehensive, carefully considered development plan. That was pretty clear, I think, in the evidence. That promoting economic development was a traditional and long accepted function of government in various respects. That the legislative bodies, here in this instance the City Council, was better suited to determine the need for and efficacy of such a development plan, and the courts needed to defer to their judgment rather than delve into the facts or make their own independent judgment. That there was extensive precedent for rejecting a literal, narrow definition of public use. We talked about that earlier. And the 2 key cases there are the Berman versus Parker case in 1954. This is one of the more important eminent domain cases. In that instance, the Supreme Court sustained the use of eminent domain to condemn or acquire by eminent domain a lot of blighted properties in Washington, D.C. in order to reinvigorate that area, including, I might add, a store that was found to be not blighted itself, but just part of this blighted area. And the other interesting case that they cite is Hawaii Housing Authority versus Midkiff. This is just a fascinating fact situation, and I was completely unaware of this until I looked at it. As recently as 1984, 47% of the residential real estate in the state of Hawaii was owned by something like 19 different people. And so there was very little real estate or homes that were owned by private individuals. And at some point, the Hawaii legislature decided that, well, this is just crazy and just distorts the whole real estate market, and so they passed a law that turned over a lot of these properties to the tenants who were living on it. And the property owners challenged that. The Supreme Court said that that was certainly a valid public use, if you will, for eminent domain, given the completely skewed nature of property ownership in that state. The dissent, a very emotional dissent, strong dissent written by Justice Sandra Day O'Connor, basically contended the court was breaking with precedent in categorizing economic development goals of the plan as an adequate public use. She argued that in both the Berman and Midkiff cases, those facts were distinguishable because the properties in those cases inflicted, she described it, an affirmative harm on society. In other words, in the one case for Berman, I suppose it was the deteriorated or dilapidated condition of the properties. In the other case, it was the ownership of all that property by a limited number of people.
And so you're implying that the properties in the Kelo case were not dilapidated?
Yes.
They had been kept up by the individual?
That is correct. That is a very good point. And in fact, that was one of the points that the dissent focused in on and that the majority conceded, essentially. There was no claim that the properties that were taken in that case were in any way deteriorated. This is I think my favorite quote from the dissenting decision. The fallout, this is Sandra O'Connor again. Day O'Connor talking, the fallout from this decision will not be random. The beneficiaries are likely to be those citizens with disproportionate influence and power in the political process, including large corporations and development firms. As for the victims, the government now has a license to transfer property from those with fewer resources to those with more. The founders cannot have intended this perverse result. You certainly get a flavor of her dissent with that particular paragraph, and you can see how strongly the dissent felt about their view on this. Now, Justice Clarence Thomas, as he often does, wrote his own separate dissent that went even further than Justice O'Connor. He declares essentially that this is just the latest case where the Supreme Court has misconstrued the meaning of public use. He essentially said that the Berman and Mitkiff cases were wrongly decided, and that we should basically go with a literal interpretation of the term public use to supposedly comport with the presumed original intent of the founding fathers, although I think that's a rather dubious notion that the founding fathers could have anticipated precisely what public use would mean in the future. But in any event, that was his particular view. That
he's a constitutionalist.
Yes, and a strict constructionist. Yes, but there's some suggestion that that's kind of a faulty reading of history. But in any event, that was the gist of his dissent. He also has a very interesting take on this. He predicted that the decision would promote basically victimization of the poor and powerless because they would be less likely to basically allege that their property was being put to the highest and best social use. It's interesting to note in that regard that the NAACP actually filed a brief in support of the property owners here. So he is taking a view that's certainly not unheard of with regard to criticizing, if you will, how government has used the powers of eminent domain over the years. In fact, there was a lot of controversial uses of that power with urban renewal in the 1950s.
Yes,
where a lot of people were displaced, and I think that's the notion that they're kind of referring to. So I think I think that's a concern that is worth some consideration. I don't think that's completely exaggerated, but. And again, it's interesting to note you never would have imagined this generally, that the NAACP would become involved, but they did. So it's let's see here. So the question comes up, would Kelo, this decision, have been decided differently in Illinois? In other words, if the Illinois Supreme Court were to look at this fact situation, would they have come to a different result? And I think there's a likelihood they would, for a couple of reasons, that the Illinois Supreme Court's interpretation of public use is notably different than that in Kelo, as described in the SWIDA opinion that we'll discuss momentarily here. In addition, the most prevalent statute that authorizes eminent domain, the Tax Increment Finance Act, requires a lot more rigorous showings as far as there being a blighted area or an area that's really drastically in need of some revitalization. And I don't know that the facts in the Kelo case would have actually satisfied the Illinois Supreme Court case.
We have many tax increment finance districts in both communities, but maybe some people don't quite understand what they are. Could you briefly just describe it?
Sure. Yeah, a tax increment finance district is a region that a local government has identified, very specifically identified the properties within it, and it has to meet certain threshold as far as being in a depressed condition, if you will. The term blight is used in the statute, and it has a laundry list of characteristics that might support a finding that it's a blighted area, and what happens once an area is defined as a part of a tax increment finance district. The local government can then plow back any property tax gains that occur from economic development over a set period of time that can range from 20 to 35 years.
Oh, it's that long. I thought it was 23.
It can be up to 35 years.
Okay.
Typically, the districts were initially 20 years, and many jurisdictions have now extended them to the full 35 years. And the key is that any kind of increase in property tax revenues in that particular area that result from economic development that the city promotes can be segregated and used exclusively in that district, whereas normally the property taxes that are collected by a municipality are put into the general fund and used for the community generally. In this instance, this is a unique instance where all of that money can be used again in that district, and it creates kind of a synergy, if you will, where a lot more money can be spent on infrastructure. And the notion is to just kind of get the engine of economic development going in an area that's been suffered from a lot of disinvestment over decades, typically. And communities have found it an extremely effective way of revitalizing very depressed areas. Now, having said that, there's been some abuses as well, and some communities in particular have created TIF districts out in farmland in order to for a carrot to bring some industrial use in, and that was really never the intent. And over the years, the statute's been modified to try to address those abuses. But I think most people who've worked in local government would agree that it's been an invaluable tool, and we've used it with great effect here in the city of Champaign, including in our downtown. That's the most dramatic evidence we've seen of the use of this, where we've revitalized the downtown essentially that was largely had vacant storefronts and really had a lot of disinvestment as recently as 15, 20 years ago. Now it's really turned the corner, I would suggest, and that's in part because of money that's been available because it's a TIF district.
But is there not another side to that story from two perspectives? First, great misuse, and our favorite mayor up in Chicago, Mayor Daley, came slowly to using this instrument for economic development, but now there are 40 TIF districts in Chicago.
Yeah, it's
hurting the school districts.
Yes, well, that's the other side of the coin, and the districts that feel like they're not getting revenues that they otherwise would get, because
like school districts, park
correct.
districts, transportation.
Yeah.
Okay.
And the bottom line is that there's a need to make sure that a district isn't being created inconsistent with the real objectives of the statutory provision, because ideally, if a district is declared to be a TIF district, and if the law is working the way it should, the notion is that the economic development would not have occurred except for that added investment. So the argument is that to the school district, well, none of this revenue would have even been forthcoming if we didn't put in place this TIF provision. Now that's controversial, and people on the other side would suggest that often the methodology is a little questionable, and maybe that's not the case. Maybe this development would have occurred anyway, and we would have gotten that revenue. But if it works the way it's intended to work, the whole process should be creating economic development that otherwise would not have occurred. So if it wasn't created, the argument in favor of the district is the school district wouldn't have realized this revenue in any event. Mm-hmm. And eventually, the notion is that once the economic development has gone to a certain point, then everyone benefits. Then there's this stream of much enhanced revenue into the future for the school district, for the park district, and all the other districts. So that's the way it's supposed to work conceptually, but it's certainly been a matter of some controversy. I would concede that.
Talk about the Illinois case.
Yeah, let's talk about the Illinois case, and that's the SWIDA case, again, involving Southwest, I forget.
Industrial development, wasn't that what it is?
Yeah, I think that's the name of it. Let me get...
Southwest Industrial Development Association.
I think that's correct. I'm forgetting what that is an acronym for. It is a nonprofit organization that was set up, I believe, in the 1980s in order to promote development in 3 of the more depressed counties in Illinois. And in this particular case, well, let's first look at the competing interests in this particular case. In this instance, it was SWIDA's desire to alleviate traffic congestion and hazards that were associated with this gateway motor raceway expansion in St. Clair County, and also to
Which is in the East Metro
Yes,
area,
it is.
just to help people place it in the state.
And to even give a better context, East St. Louis is in St. Clair County, and East St. Louis is arguably the most depressed municipality in Illinois. It's starting to pick up, but
not unlike New London.
Yes, not unlike New London, absolutely. There was some evidence that those attending this Gateway Motor Raceway were causing backups on the interstate whenever there was a racing event, and that there was a lot of conflicts between pedestrians and cars when the people were crossing from the existing parking lots into the raceway facility. And there was also a fair amount of evidence that a lot of commercial development had happened since the racetrack had opened in 1997, including the expansion of existing businesses and creation of new ones. And there was some suggestion that several blighted properties had been removed as a result of ancillary economic development related to the raceway. But as we'll see, I think the Illinois Supreme Court, frankly, properly discounted that as being a real significant element. On the other side, you had NCE's, National City Environmental's desire, of course, to retain their site for their metal recycling center, not having to uproot it and move to another location. They had been there since 1975, employed 80 to 100 persons full-time. And let's look a little of the history and purpose of SWIDA. It was created by the Illinois legislature in 1987 through passage of the Southwestern Illinois Development Authority Act, an act that stated purpose was primarily to promote transportation and recreational activities and facilities, thereby reducing the evils attendant upon unemployment and enhancing the public health, safety, morals, and happiness and general welfare of the state. Again, general reference to the fact that this particular area was somewhat depressed compared to the rest of the state. Included Madison, St. Clair, and Clinton counties, three of the more economically depressed counties in the state. And the powers of this nonprofit included, of course, the authority to issue bonds to fund development projects. They did, in fact, issue a very large bond issue in order to provide funding for the actual construction of the motor speedway, and to exercise eminent domain to promote the purposes. And, of course, that's the controversy that's at the heart of this particular case. The impetus for its exercise of eminent domain in this particular case is there was a very brief, unsuccessful attempt by the Gateway folks to work out a voluntary acquisition from National City Environmental, and then they put in a quick take application packet that SWIDA had created. And this is an interesting aspect of this case, which I think, frankly, the court found particularly offensive, and I think was really the driving force behind the decision in this case. There's this application that anyone could make. They just have to pay a $2,500 application fee and pay a down payment on what the ultimate fee would be to SWIDA for the acquisition of a particular property that a developer would want for his development. Again, you had a fair number of levels of legislative involvement here before you actually get to the point of eminent domain, and that's always important to keep sight of. Here, this county board had to approve the application for the quick take, and quick take is the power to take title to the property in a very short schedule and defer the court's decision on fair compensation afterwards.
I see. Okay.
The notion being that we can't wait for the judicial process to go through and make that determination. We need title and possession of the property sooner.
All right.
And in this particular case, SWIDA did have that quick take authority. And in that particular instance, the county board found that there was a dramatic increase in attendance at the racetrack, and that it was necessary to provide parking to serve the patrons, and that the expansion would enhance the track would enhance the public health, safety, morals, happiness, and general welfare by increasing the tax base in the area and generating additional tax revenues. SWIDA, the actual nonprofit organization that we're focusing on here, then had to approve by resolution the application as well. And this was had at a public hearing on March 5 of 1998. And in that public hearing, at the conclusion of it, they found that there were numerous benefits for the region that would follow the racetrack expansion, and that the acquisition of the property was essential to promoting the expansion of the racetrack. Now, the evidence presented in the circuit court when...
and again, the racetrack is a private concern.
It is, yes.
Yes,
That's
okay.
a key element here, that it's
Okay.
privately owned. It's not a government-owned facility. And the evidence that was presented in the circuit court when NCE, National City Environmental, objected to this acquisition, key elements included that testimony that there was significant traffic congestion on Interstate 5570. There was testimony that cars were literally backed up and stopped on the interstate on race day. Mm-hmm. There was testimony about pedestrians having to cross in the middle of a block adjacent to one of the parking lots, crossing over to the raceway, and that this posed a serious hazard. There was also a testimony that developing a parking lot west of the racetrack on the site would alleviate this traffic congestion. And there was also testimony that neighboring businesses since the development of the racetrack had exceeded SWIDA's projections. In other words, the economic benefits even were greater than what they intended. Yes, that there was quite a bit of economic development after the racetrack opened, and something in contrast to what was going on years before that. There was also some testimony that some blighted properties happened to be eliminated during this economic development, but frankly, that testimony, I think, was pretty weak, and there weren't that many properties. So, and the court, again, discounted blight abatement as a really serious objective of this acquisition. There was also testimony that Gateway had explored building a parking garage on its existing site, but considered it too expensive. They had testimony that it was just economically infeasible, but didn't go beyond that, really. And this is a key element that the Illinois Supreme Court really focused in on in deciding that this was not a proper exercise of eminent domain. The opinion was written by Justice Rita Garman for a 5-2 majority, and in that opinion, essentially, they said that the exercise of eminent domain in this particular case did not satisfy the public use requirement of the Illinois Constitution, that the taking in this instance was primarily designed to allow Gateway to expand its facility in a less expensive manner and essentially increase their profits, and allow them to avoid needing to do some serious negotiation in the open real estate market. And there's some support for this in the sense that this process all happened within the matter of like 6 weeks from the date of the application until a court ruled that they would take the property.
That was
very
fast.
dramatic and frankly, I think pretty much an abuse of the power of eminent domain as far as how it was carried out here. And I think that really was carried the day for the majority. They basically found that the potential economic and safety benefits were pretty incidental, and that the major benefactor in this particular case was the Gateway Motor Raceway entity. Mm-hmm. Key considerations are, again, that that SWIDA just had this general process that they offered to anyone to exercise eminent domain on their behalf for the payment of a fee. That, I think, was very troubling to the Illinois Supreme Court for reasons I can really appreciate here. Also, that Gateway did indicate that, they did explore constructing the garage on their own property. The majority opinion really focused in on that and viewed that as basically testimony that they were just trying to do this more inexpensively, and that it really wasn't essential for them to acquire this other property. Another real key point here is that SWIDA failed to conduct or commission any real thorough studies of the parking and traffic issues regarding this expansion. They essentially kind of related back to the original objectives of SWIDA. Then they called witnesses at the trial level to kind of after the fact to offer support for this, rather than really conducting the kind of studies that were apparent in the Kelo case, for example. So this is a striking contrast in facts from the Kelo decision.
So they didn't prove that this would eliminate the traffic backup, or that people wouldn't have to cross in the middle of the highway.
They didn't really study it to any significant degree to warrant deferring to their legislative decision. Right. It was kind of a snap thing that happened, and I think that's a real fair criticism of how the exercise was performed in this particular case. This is in that same vein. They failed to really formulate any economic plan that required this additional parking. In other words, they didn't do any further studies, and I think that's a very valid complaint or a point by the majority opinion in this particular case. The majority also found that blight abatement was just really a non-issue here. That if there were blighted properties, it was a small number, and so that really couldn't be used as a valid justification for the taking in this case. Now, there's a very strong dissenting opinion by Justice Freeman, in part because, frankly, this particular opinion is quite confusing, and it's not clear to practitioners what the future holds as far as the exercise of eminent domain in the state under this ruling, because the court kind of, in an offhanded manner, talks about public use, a literal interpretation of public use. In other words, and they cite a 1903 Illinois Supreme Court case that stood for the proposition that it wasn't a valid public use unless the public had unfettered access and control over the property. And that view has long since been rejected, even in Illinois. And I don't really think the majority meant that, but they said it, and so they kind of confused the issue for people trying to predict what will happen in the future, because the court, by the same token, cites with approval the Berman case that we talked about earlier, use of eminent domain for blight abatement, and in that case, invariably, you're turning the property over to private property interests, and they cite with approval the Midkiff case as well that involves the state of Hawaii. So you can't really reconcile that statement with their discussion of those Supreme Court cases. But it's kind of confusing, and the dissent kind of focuses in on that, kind of suggesting, I think, fairly that the majority opinion really didn't, it kind of ignored the Illinois and U.S. Supreme Court precedent to the extent it makes that statement that, for it to be a public use, it really has to be the public using it. Noted that the majority ignored some unrebutted testimony at the trial court. I think that's kind of a fair criticism as well as the majority of opinion. And again, refers to this early 20th century case, which just kind of baffled a lot of us practitioners as far as, how far are they going to go with that. Now, since this opinion, and in large part, I believe in response to the Kelo case, interestingly, rather than the SWIDA case, the Illinois legislature has actually passed a comprehensive change of the eminent domain laws in Illinois. And this is a good illustration of that point we made earlier, that while the power of eminent domain has existed for centuries and relates back to early English common law, over the years it has been restricted by constitutional provisions and by legislation. And in this particular instance, the Illinois legislature, I think in large part in reaction to this very controversial Kelo case, has done a complete comprehensive overhaul of eminent domain law in Illinois. And quite frankly, it's somewhat confusing, and some of us are not real clear on what the meaning of these new provisions are. But
so it's going to have to be tested.
It's going to have to be tested out. Some of the provisions are going to be tested out. Some of them are pretty self-evident, but I thought we'd kind of just review some of the highlights of that new act.
Let's just momentarily comment that Illinois is not not alone in reacting this way to the Kelo case.
Absolutely not.
Okay.
In fact, 20 to 30 states are doing likewise, passing legislation in reaction to what's been widely viewed as a case that authorizing the abuse of eminent domain. The Kelo case has been roundly criticized, and all you need to do is do a Google search of the word kilo and eminent domain, and it is astonishing how many articles you will get hits on, most of which are highly critical and somewhat alarmist, I would suggest. But I do understand the reaction to that, given the facts in that case. I think the consequences of the case are greatly overstated by the critics of that particular decision. But in any event, that's the reality of it, that it's created an uproar that, again, has taken many of us.
And it's divided many groups. The American Planning Association did submit an amicus brief for this case, yet many members of the American Planning Association probably line up to be critical of the case. So the divisions are quite numerous.
Yes, it's generated more commentary about the notion of eminent domain than probably any case in decades.
But the positive side is that it's really getting people to think about land use.
It is, and I don't know that some of the provisions of the new Eminent Domain Act in Illinois, I think, are overdue, frankly, to address some of the abuses of the process and the kind of onerous impacts that the process can have on private property owners. Some of them, I think, are an overreaction, and some of them are, again, you're going to have to be tested in court about what they really mean, because there's still some vague terminology used, and I don't know that we still have a really crisp understanding of how far the Illinois Supreme Court will go in invalidating the exercise of eminent domain in the future.
Let's talk about.
The act in question.
So our viewers will learn about what is now law within our state. I see the 1st of January.
Yes, and
not quite law yet. Sorry.
Well, it is. No, it is. Yeah, it will be effective January 1st, 2007. It has been actually adopted and signed by the governor. And one key thing that it does is it does carve out a lot of exceptions for things that we think of as
O'Hare.
Yeah, O'Hare, of course. This is a fascinating case study of the kind of compromises that happen in legislative process. I mean, it's pretty clear that there was a very strong political component that said, absolutely no way do we want you to touch our ability to acquire property around O'Hare Airport.
We don't want Peatone to happen.
That's right. So this is kind of a concession to the constituency up in the Chicago area that is very much committed to expanding O'Hare, so they had to kind of throw that in there.
Right.
There's also an exception for existing plans that had already been adopted pursuant to the Tax Increment Allocation Redevelopment Act. Basically, the notion being, let's not change the rules in the middle of the game. We've gone through this elaborate process, and the law is quite comprehensive, and frankly, I think pretty well crafted to avoid most abuses. So I think this was a reasonable compromise, that we're not going to apply this retroactively to properties that were already in a TIF district.
And that's Daley's 40 TIF districts up in Chicago.
Yeah, well, I can't speak to that. I can. We've got I think 3 TIF districts here in Champaign now, and I don't remember how many Urbana has. And I think it's fair to say that we've used TIF districts here
judiciously,
in a restrained way and for very valid purposes. So I can't speak to what's going on in Chicago, and I'm really not that familiar with the facts. Also, the act will not apply to actual complaints filed in court before the effective date of the new act. It also, interestingly, I think, reaffirms that blight abatement is a valid public use. In other words, there's the legislature saying, we as the legislature agree that blight abatement is a valid public use for eminent domain, even if the properties are ultimately turned over to private ownership and control. It does, however, eliminate the ability to establish a prima facie case. That means a case, you've established your essential case that a court can base a favorable ruling for you upon, and then it's up to your opponent in the case to present evidence to contradict what you've basically presented. It eliminates the ability that has existed for years now to establish a prima facie case by merely offering evidence of approval of an ordinance or resolution designating an area as blighted. In other words, traditionally, you attach that to your complaint in court, and all you would have to do is offer evidence that your city council actually passed this ordinance and said it was blighted. Well, now the suggestion is that you're going to have to actually offer competent testimony from some witness about why it's been characterized as blighted. And I think if you're not abusing the process, I think the municipality will be able to do that. But it's a significant change, and for the court to get into that process and for the opponent to be able to cross-examine the witness and really scrutinize the designation of an area being blighted. Okay, well, we'll have to.
Oh, he can do it from the other room.
Okay. We've got some other points highlights that I'd like to focus on. The new act imposes a heightened burden of proof by what's called clear and convincing evidence when a property is acquired for private ownership or control, except for a number of articulated exceptions like blight abatement and for like a railroad or for a utility of some sort. And those are in here: blight abatement, private utilities.
Okay.
Clear and convincing evidence, it's kind of hard to quantify it, but it's somewhat higher than the normal civil burden, which is preponderance, or more likely than not, 51% likely that your side is accurate, but less than the criminal burden of proof of beyond a reasonable doubt. Now, so how that plays out in the real world is kind of mysterious, but essentially the notion is, well, you got to offer a little more evidence, and we're going to put you to a more stricter burden of proof. If you're trying to validate your exercise of eminent domain for reasons other than blight abatement or for a utility of some sort. We also, another key change in the Act is that it will define compensation to include relocation costs as defined by the Federal Uniform Relocation Assistance and Real Property Acquisition Policies Act. That's a mouthful. The Federal Act, for all, has largely affected a large percentage of eminent domain actions over the years anyway, because in any instance where any federal money is involved in the project, this act automatically kicks in. So there's a long precedent in many cases for the condemning authority to have to pay these relocation costs in those cases. Well, now the Illinois Act says anytime anyone in Illinois is exercising eminent domain, you also have to pay relocation costs.
Not
just fair market value, which is the standard for fair compensation in the past. And to me, that's an eminently reasonable thing to do. You're basically taking property from someone who wasn't prepared to put it on the market themselves, and typically implicit in that, you've got some real hardship for them having to move to another location, whether it's a business or a homeowner.
Right.
So I think most people, even who favor a broader view of when eminent domain can be exercised, would applaud this and say this is appropriate. And my own feeling is that this should be more of the focus of legislative action, making the process a little less burdensome and painful to the property owner, rather than focusing on some of these other questions. Another thing that the new act allows is that the jury can award compensation based on value determined as of the date as late as the commencement of the trial. Now, the significance of this is that historically, the value was always established as of the date the complaint was filed. And in many instances, that could be 2-3 years from the date of ultimate decision. And I think reasonably, people over the years have said, well, that's completely unreasonable. I mean, the property might appreciate in value significantly.
Market values change.
And so I think this is another really healthy change that's been made in the law that, that gives the court discretion to look at value as late as the commencement of the trial in those cases where there's been a delay in the trial occurring. Another key aspect of the new law is that it provides for property owners' attorney's fees if the jury ultimately awards compensation that exceeds the original offer made by the condemning authority. The notion here is that we want to deter governments from kind of lowballing, for want of a better term,
Okay.
getting some appraiser to just kind of give them a low appraisal and just
Mm-hmm.
make that offer, and then start the eminent domain process, and arguably not really negotiate in good faith. Well, here the new act says if you make an offer and the jury ends up coming back with an award significantly greater than that offer, you'll have to pay a percentage of the other side's attorney's fees in order to deter
Because
that.
it costs him to come in and do this.
Absolutely,
Okay.
absolutely. So, and I think that might be a reasonable change as well. It'll certainly cause municipalities to that are less inclined to do so to really negotiate in good faith. Now, speaking for the city of Champaign, we always invite getting an appraisal from the other side, and we'll often pay in the value shown by the private property owner's appraisal, unless it's patently ridiculous. So the city, and certainly the city council, feels this way, that we're going to negotiate in good faith. Other communities may not really take that approach, and I think that particular change that we just alluded to is designed to deter abuses in that area.
Right.
But again, it's going to be very interesting to see how different fact situations are addressed by the courts under this new act. A lot of us are not really clear on what the outcome of that would be, because the act has some very interesting provisions in it that some of us are not sure what they really mean. And another point is that the act still does not define public benefit. So there's still wiggle room here where the court's going to have to come in and say, well, what does that really mean?
Right.
And the court will still need to rely on case law precedent and an interpretation of the Illinois Constitution. So the new act, in my view, doesn't eliminate all the questions, and it's not going to eliminate all the future litigation. And we'll have to just see how it plays out as far as where Illinois will ultimately come down on balancing again the interests of the private property owner and the government in acquiring the land.
It is a good step, though.
I think I like some of the things about the act. Other things I think are just kind of unnecessarily confusing the issue, and I have mixed feelings about it. I wish some of the language was clearer, just from a practical standpoint, because as a practitioner, we want to do it right. I mean, we want to avoid having to go to court, and we want to avoid the uncertainty. And so, to that extent, my view, and I think the view of a lot of others, is through the compromises that occurred, some of the language is a little fuzzy, and we'd like it to be a little clearer. But again, I would agree with some of the provisions in there, and I think they're a good step forward as far as again, striking a proper balance in the situation.
This has been terrific, and I hope all of you have learned a lot about eminent domain and the importance of property rights, specifically now in Illinois. Remember, planning matters.